case Trump v. Anderson, seeking to determine whether or not to affirm or reverse a ruling by the Colorado Supreme Court that Section 3 of the 14th Amendment disqualifies Donald Trump from serving as President of the United States. A lot of briefing has gone. It's come before the court very quickly, but within a short amount of time, a lot of people have done a lot of writing, a lot of arguing on both sides. The court has just thousands of pages of amicus briefs that they have to read that cover different aspects of this text behind us. And Professor Chambers and I are going to talk about different aspects of the text. You'll have your own questions about the text. I have submitted an amicus brief in the case that focuses on one particular aspect of the text. And so what I'm going to do just here in the beginning, I'm going to take about 4 or 5 minutes just to talk about the small role that I'm playing, just in terms of my argument. And then Professor Chambers will give his presentation. When it opens to you, obviously you can talk about any aspect of the issue and this particular challenge in interpreting the 14th Amendment. Okay, so some people are talking about whether or not the events of January 6th amounted to an insurrection or rebellion against the Constitution of the United States. There are arguments about whether or not the actions or inactions of President Trump on that day amounted to engaging in insurrection or rebellion against the Constitution. Other people are arguing about whether or not Donald Trump is an oath breaker covered by the specific oath texts in Section 3. That's kind of the middle portion of the second portion of Section 3. My work has focused on the opening sentence, what I think is the threshold question in the case. And that question does not involve whether or not the president holds an office. The question that I'm addressing is whether or not the president holds a civil office under the United States. I think that question is far more difficult and historically complicated, and the brief that I presented to the Supreme Court argues that it's possible to read that text in different ways, and that the ambiguity in the text was not resolved by the ratifiers. Therefore, it is inappropriate for the court to apply that text in a manner that would prevent the American electorate from voting for Donald Trump. Now, again, just to briefly explain the constitutional argument that I'm making, I would start by sort of broadening the question to talk about the 14th Amendment. Some of you taking constitutional law too. Some of you are certainly free, as I tell my students all the time, to Google the 14th Amendment right now if you'd like to look at it. The 14th Amendment is full of broad words that are restricted by their placement in a larger legal phrase. The Due Process Clause does not just speak about liberty, it talks about persons deprived of life, liberty, or property without due process of law. The Privileges or Immunities Clause doesn't just talk about privileges, it talks about privileges or immunities of citizens of the United States. And in the same way, Section 3 does not just involve offices, it involves offices, civil or military, under the United States. And just like the Due Process Clause and the Privileges or Immunities Clause, prior to the adoption of the 14th Amendment, that phrase had already had a long history of legal construction. At the time of the 14th Amendment, well-established congressional precedent and legal authority defined phrases like civil officers under the United States as applying to appointed offices and not to the apex political positions of senator, representative, or president of the United States. That principle, believe it or not, goes all the way back to 1799 and is something that came to be known as Blunt's case. And it was the authoritative view of Justice Joseph Story in his very influential commentaries on the Constitution, that the phrase civil office under the United States is one that applied to appointed office and not to the apex position of President of the United States. You can also find this in the debates of the members who participated in the framing of Section 3 as well. Now, when it comes to the actual framing of Section 3, an early draft had expressly included the office of President of the United States. The final draft did not. That language was omitted. And instead, as you look at the text above me here, the final draft lists specific offices and methodically moves from the high offices of senator and representative down to a general catch-all phrase that everyone in this debate agrees includes the lowest appointed offices. And that structure naturally reads as if the framers expressly named all the high offices they wished to include, and they did not include the president. Now, in my brief, I concede that it is possible to read that catch-all phrase as including all offices, including the office of the President of the United States. But because of this legal and congressional presidential background, it could be read either way, and that left it in the hands of the ratifiers to decide how to resolve the ambiguity. However, despite dogged efforts by every historian on every side of this case, no one has found a single ratifier addressing the question of the office of the president at all. It went undiscussed and unresolved. I also argue that there wasn't any reason for the ratifiers to want to talk about it or to address the issue because they wouldn't have thought that it was important. No Republican at the time worried about the nation as a whole electing Jefferson Davis as President of the United States. Instead, Republicans understood that they faced a very real and imminent danger arising out of state-level pockets of rebel disloyalty. Influential rebels might exploit the remaining local popularity and secure selection into the Senate, election in the House of Representatives, or serving as a presidential elector. And once in those offices, they would then join other Democrats in obstructing the civil rights legislation that Republicans were trying to pass, or they would join their electoral votes not to elect Jefferson Davis, but to elect a Northern Democrat like Horatio Seymour, who ran against Ulysses S. Grant. Section 3, I claim, reasonably and successfully addressed those very real concerns and did so without going further and needlessly abridging the right of the national electorate to choose their president. At the best, the language of the text is ambiguous in that regard, and so therefore it should be left to the people to make their own decision as to whether or not to elect Donald Trump. I now hand it to Professor Chambers.
Sure. Thank you. Thanks, Bunch. I appreciate. I'm just checking time to make sure that I don't go too long, because I don't want to speak for terribly long, because there are a lot of issues that need to be addressed here. I am not going to get into the specific historical record on those issues. I want to talk a little bit about the language of the 14th Amendment, Section 3 for a bit. Those folks who know me recognize that when I think about constitutional law and constitutional interpretation, tend to ask three questions. What does the text say? What does it mean? And how does it apply? And in thinking about those issues, one of the things we have to consider with the 14th Amendment, Section 3, is what it's about. If you read it, what is it about? And it's what I call the fool me once section of the 14th Amendment. If you read it, it doesn't say if you have engaged in rebellion or insurrection, then you can't serve. It says if you took an oath before, then you engage in rebellion, we're not going to let you serve in an office where you've got to take the oath again. You fooled me once, shame on you. You fooled me twice, shame on me. And when you think about that as being the nature of the section, and when you think about the notion that Congress can remove that disability, then it makes a lot more sense to say, oh, okay, I understand what this is about. Now you can ask questions about who should be covered and what offices should be covered. Now, part of what we can ask is whether one who read this section would think, I wonder if Jefferson Davis could be elected president. Or, I wonder if Robert E. Lee could be elected president. Because my understanding is that there were folks who made those arguments, and that was an issue before the 14th Amendment was passed. So I'm not terribly sure that there was no one out there thinking about those particular issues. Now, there's no question that the language does not explicitly talk about the president, and it may well be that the language doesn't talk explicitly about the president because there was no real need to think explicitly about the president. That is to say, the notion was, well, clearly it covers everybody else, and there's a reason for us to talk about everybody else, and we want to make sure it covers everybody else. No one would have thought that the president would not have been covered under Section 3 of the 14th Amendment. Again, I recognize that there are some specific arguments that folks can make, but that's a big part of what's being argued. Now, there's a second piece, and we can certainly talk more about the amendment, why it was there, issues along those lines. But I do want to mention one other piece, and that is the question about keeping one off of the ballot. Because arguments have been made that, well, regardless of whether one is disqualified or not, one should be allowed to be on the ballot. And here I think it's reasonable to ask, what is Colorado's interest in keeping anyone in particular off the ballot? I think the argument that Colorado would make is, or the argument that you make is, why should we have our process of a state-involved primary? Yes, it's the Republican primary, but a state-involved primary. Why should we have someone on the ballot who can't serve? Whether it's someone who can't serve because they've already served 2 terms, whether it's someone who can't serve because they're under 35, whether it's someone who can't serve because the 14th Amendment Section 3 says they can't serve, we think it makes sense under our law to remove anyone from the ballot who can't actually serve as president, and that would seem to make some measure of sense. Like I say, there's some folks who argue, go ahead and keep anyone on the ballot and figure it out later, or think about it for the general ballot. But I think it's fair to say that Colorado's position that they are involved as a state with the primary makes them say we ought to be able to decide who's on the ballot so that Colorado voters do not end up wasting their time and wasting their votes on someone who can't necessarily serve. So there are a number of other issues that will pop up, but I'm curious as to what folks are thinking and what is triggering, not in that way, but what is starting to make you think about what should we be looking for in the argument tomorrow morning. So I'll stop there, because as you well know, you could wind me up and I could talk for the rest of the time, so I don't want to do that.
Did you want to have questions there, or did you want to respond to it at all?
Just briefly, Professor Chambers has raised a really tricky issue, and it's not one that I have any particular answer to. Where the court is facing all these different questions about, there's the high-level question of, does it apply to presidents at all? If it does apply to presidents, does it apply to this type of event, January 6th? If it does apply to January 6th, does it include the actions or inactions of Donald Trump? But then we get to relief kind of things. The actual issue before us is, can Colorado do this thing, right? And they could arrive at all kinds of different conclusions. You can or you cannot have authority to keep them off of the ballot in Colorado, the primary ballot, and there's a general election ballot. Then there's states, they might say states do whatever you want to do, but then Congress can make the final call when they count the electoral votes, Or maybe this will come back before the Supreme Court at a later date. There are a lot of hugely complicated issues that the court might choose to address or resolve the case under that would leave this bubbling in the states in one way or another, but would require the Supreme Court to come in again, perhaps, at a later date. So that's a very important complexity that you're going to hear questions about in terms of what states can and cannot do tomorrow at oral argument. I think also Professor Chambers has very fairly raised counter arguments. Why would anyone want Jefferson Davis to be president? And if they looked at this text and they were concerned about Jefferson Davis or Robert E. Lee, I can see them thinking, I want to read this in a way, or why not read this in a way that keeps them off the ballot? It's a fair question. One of the ways that I've tried to address it is that it focuses on the bad person in front of you instead of focusing on the mechanism. Right? The way I'm reading it is that the mechanism it focuses on is a mechanism of state-level decision-making. That's what we're worried about, state-level pockets of rebellion. When you talk about Jefferson Davis being president, you're not talking about keeping Jefferson Davis from being president. You're talking about stopping the people from voting for Jefferson Davis unless they get permission from Congress. So you're no longer just focusing on bad people on a state level or voting on a state level. Now you're talking about broadening it in a way that actually restricts the national electorate. And I think that's very different and would have required more specific words.
Yeah, that actually raises a real interesting question. One of the things that one of the hobby horses that I ride, or soapboxes on which I stand during my voting rights class, technically a seminar, voting rights seminar, is that there are very few offices that are truly federal offices. And folks usually say, well, I don't understand what you're talking about. I said, well, look this way. Senators are elected from states. Congresspeople are elected from states. The only person who is elected from a more national electorate, and it's not really national, it's really a federal electorate, because our electorate in Virginia is completely separate, hermetically sealed from the electorate in, say, Ohio, is in theory the president. So it makes the nature of federal office a little bit different, or the concept of a federal election. Really, every election is a state election for federal office. So if we think about an election as a state election for federal office, what we recognize is it turns out that there's some strange things that are going on here. It's one of the reasons why I say this is the fool me once, fool me twice amendment, is you actually had some folks who served in the Confederate Army who served as electors for president. So that, at least from a theoretical perspective, there are lots of folks who could have decided to vote for Robert E. Lee or Jefferson Davis as electors, and the 14th Amendment said we wouldn't have stopped them. So there's an argument that says, really what's going on is it's not just that you're trying to keep some people out of office, you're trying to keep people out of office who have pledged or who took an oath, broke it, and now need to be in a position to take the oath again. So I say that to say that there's a reason to believe that this would not have stopped folks from electing Robert Lee or Jefferson Davis under certain circumstances, because the people who would be supportive of that might well have been allowed to serve even under Section 3 of the 14th Amendment. And that's one of the reasons why arguably what you want to do is say the amendment itself stops anyone from selecting those folks, because people who might want to select them could well be in office to do so. It's a tricky kind of amendment. It's messy. I'm not saying it only takes that single interpretation, but it certainly could. It certainly could.
Okay. Well, I think we'll open it up for questions. Then just put on the microphone and a microphone, so raise your hand and we'll start. Let's start over here.
Hi.
Hello.
So I'm not an attorney or in law school. I have lived with one for a long time. Here's my question. Who cares whether he's on the ballot or who's on the ballot? Isn't a write-in campaign possible? And what happens with that? There seem to be plenty of people who feel very committed to a particular candidate. Can't they be organized to write him in?
Depends on the jurisdiction. There are a number of jurisdictions where if you are not a candidate on the ballot, no votes will count for you. So that's actually an issue. Depends. It's a state by state question, and on that state by state question, you may well have no opportunity at all to be elected if you're not on the physical, if your name's not on a particular ballot. A lot of messy election law stuff that pops up. And that is a slight distinction between voting rights, pure voting rights, and election law, although we cover some of both of that in my election law or my voting rights seminar.
I think it's a great question, and again, it's one that I would go straight to Professor Chambers to get answers for. So I think Republicans in Colorado have said we're going to write in the name, no matter what happens, we're going to write in the name. So there's a question of whether or not that's allowed. Am I right to think that there's also a possibility that, regardless of the actual voting rules, that the electors might say, even though our state said that no one could vote for Donald Trump, faithless electors, or whatever the word would be, could then make the decision. And then on top of that, no matter what they do or what they write in, then it's up to Congress at the very end, when they meet in joint session with Kamala Harris presiding over the counting of votes, that Congress can decide whether or not to accept the decisions of those below who wanted to vote for Donald Trump, because Congress thinks that he's disqualified under Section 3. So aren't there several levels all the way up?
There are levels of messiness. Whether we get to all of those is often a matter of state law in some respects. Your faithless electors, those folks who don't vote for the person who wins the state as such, fewer and fewer of those exist, because we have more states that have said, no, we're locking that down. And a couple years ago, the Supreme Court said states can lock down electors so that faithless electors can be removed and can also be fined. And in that respect, you're probably going to have a lot more discipline in that respect. So it's theoretically possible, but vanishingly small possibility is out there.
Other questions?
I say, don't be. I know there are questions. Don't be shy.
I can just talk about it. Okay, thanks. Yeah, so this is a question for both, but I guess it deals more specifically with Professor Lash's arguments on the first sentence.
Sure.
So if we accept Justice Story's argument that, okay, the office of the president is not a civil office, would he still not count as a military officer, as commander-in-chief, and then we can just kind of sidestep this and it would still apply?
I've heard, I often get that question, and it's been discussed by scholars. It's a good question, because then even if Story's right, boom, it's gone. Most of the people I talk to, and it's also my position that the president would not at that time have been considered a military officer, and that in fact the president is not a military officer. We have civilian control of the military. We have a civilian as commander-in-chief of the armed forces, and that's why the president isn't subject to the military code of justice. And so as a matter of fact, he isn't, and there isn't any historical evidence that I've read that anyone at the time considered him to be a military officer. But it comes up all the time because it's another possible reading of the text, and it is, I think, reasonable for people to wonder whether or not he is a military officer. So at most, that also would have been ambiguous. That would have had to be resolved, but it didn't come up. It didn't come up at all.
Yeah, one of the things to remember is that the Constitution certainly exists, has been around for a long time, and this particular provision has been around for, 160 or so years, almost 160 years. Right. Lots of it has gone uninterpreted. Now, one of the things you can do if you look at that language is you can ask, well, one, why are we doing so much with commas? That's one question you can ask. But another question you can ask is, it says, or hold any office, civil or military, under the United States. We might argue that with those commas being in place, it covers every office, and every office is either civil or military, so as long as there's an office under the United States, it's covered by that. You then go to other parts of the Constitution, which of course talk about the office of the president, and you say, well, okay, is it an officer someone who holds an office? And to the extent that the Constitution notes that there is an office of the president, doesn't that make the president an officer? And the response may well be, well, of course so. Or the response may well be, I don't think so. That's part of the problem with the interpretation question, and we're always back to the original issue of, so we know what the language says. The question is, what does it mean, and then how does it apply? I think it's fair to say that most folks reading the text if they were just asked without any other issues, do you think the president is an officer of the United States? You read the full text of the Constitution, I think most people would say yes. I think they would say yes. Maybe they would be wrong, but I think that they would say yes because someone who holds an office that is defined as an office in the Constitution would seem to be an officer. So I think you got to go a little ways to convince folks that someone who holds an office is not an officer under or of the United States of America.
Just a brief interjection. I agree with pretty much everything that you said until that very last. No. This is important because there are other arguments. Professor Chambers was addressing a very major argument that is not mine up until the very end. Then you said something that did call my ideas into play. Some scholars are arguing this question about offices and officers. And if the president holds an office, is he nevertheless one of the officers of the government who would be subject to the text, in particular the middle aspect of the text. And I have not addressed that issue because I haven't seen. I do take an interpretation from the position of an originalist, which means that I look at public deliberation. All of my efforts are towards trying to figure out how the public understood what they were doing. And I've seen exactly what you just said, that people talked in offices or officers, and they didn't make that kind of really fine distinction. So I don't challenge any of that. That does seem odd. They would have, it seems to me, thought of the president as an officer holding an office. But the word under, right, I think is significant. And I think if you ask people, what do you think the word under means? I bet you get a lot of different answers, right? Because it isn't clear. It doesn't have an intuitive meaning. And then civil, even civil office under, who are the civil officers? They're actually, I think, I have found a lot of people talking about, well, civil officer is someone who was appointed by the government, and there really was a lot of conversation about that combination of terms, not just office, but civil officer. But then when you add civil officer under, now I begin to get a lot of blank looks. I don't know what under means. And that, to me, is very important. So even if he holds an office, even if he's an officer, and I concede all of that, it's that extra additional phrasing that I think makes it so difficult.
So my question, I guess, starts for Professor Lash and then goes to Professor Chambers. So I think we can all agree there's a lot of ambiguity in the way this is written. And from understanding your argument, Professor Lash, you're saying that because of that ambiguity, both in the way that it's written and in the kind of historical context, the court should kind of let it go to the electorate and not kind of rule on blocking Trump from being on the ballot. But I'm curious why the analysis kind of stops at, oh, there's ambiguity, therefore let things play out, rather than, oh, there's ambiguity, so let's look at kind of what makes sense. Kind of like, let's look at Professor Chambers, like, fool me once, shame on me, fool me twice, shame on you, sort of thing. Or I guess it's the other way around, sorry. But, like, why stop at ambiguity? Why not say, oh, ambiguity, let's just go to what seems to make sense?
That is a great question. You have to have a follow-up rule. So we've got ambiguity, but that doesn't tell us how to resolve the issue. Again, from my perspective, you kind of, I think maybe some of your opening comments were moving in this direction as well. There's a question of whether or not applying this in a way that disqualifies Donald Trump is anti-democratic. And so maybe your default rule is don't do something anti-democratic. If it's ambiguous, let democracy play out. But there's an obvious response to that, right? And there's lots of stuff in the Constitution that's anti-democratic. There are all kinds, and including involving the election of the president. No matter how much the electorate wants to exercise democracy and vote for someone under the age of 35, not allowed to do so. That's taken out of play. That's a qualification. It can't be waived. Same thing, it has to be a natural-born citizen, the Arnold Schwarzenegger situation. And we don't consider those anti-democratic, they're just qualifications on the presidency. So maybe this presumption doesn't work in this case because participating in insurrection or rebellion now simply has become another qualification. And my answer to that is that works if that's what the people did. The 35-year-old restriction and the natural-born citizen restriction are expressly stated in the text. They were expressly debated in the ratification conventions, and after all of that, the people decided to make it part of the Constitution. And I don't find the same kind of express text here, and I don't find any kind of robust discussion at all. So under the principles of popular sovereignty, I would say that unless the people have added a restriction, then automatically, just as a matter of constitutional theory, if it hasn't been entrenched in the Constitution, then by default, it simply remains subject to political discussion. So that's why I resolved the ambiguity this way.
Yeah, if there's hardcore ambiguity, which of course is a question.
Yeah.
We talked about, in criminal law, we talked about the rule of lenity, and my students are like, yeah, please don't go into that again. But we talked about it, and finding ambiguity is the first step. So part of what the court's going to have to ask is it ambiguous? Or will the court say, no, we know what it means. And everybody knows what it means, because at that point we don't have the ambiguity, but that then becomes the place where you say, well, let me find something. One of the things that we run into when we think about this issue involving Donald Trump, and we kind of want to, I kind of want to move away from, well, it's not that I want to move away from Donald Trump as Donald Trump, but I want to move away from the question of the presidency and think for just a moment about who this covers. So if you have a state delegate who took an oath to support the Constitution, because Article 6 of the Constitution requires that state delegates take an oath to support the Constitution, who then showed up on January the 6th, and assuming did something that qualifies as engaging in an insurrection, that person is not supposed to be allowed to serve as a state delegate again, unless Congress, by 2/3 vote, says they can serve. So we're not talking about someone who has run for federal office, we're talking about someone who's run for state office. So this amendment clearly says state officials who take an oath and then violate that oath then can't serve as a state official again. We can say, wow, if that's the case, boy, does it seem really strange that a president could take an oath, violate it, and come back and be reelected. Now, that may play into the question of whether folks think that the language is ambiguous. That is, given what it covers, we may say it's not really ambiguous on the presidency. And at that point, we would be done. But, on the other hand, folks may well say, no. Even though it covers all of those people, it still is ambiguous on the president, and that's why we then keep talking about what it covers. So part of this is, remember, one of the things we do in law school is we say, where are my legal pegs? And where can I hang my coat, my argument on that legal peg? So that's part of what we're trying to do. Now, we as academics, we're not trying to do that. Eventually, we may end up in that point, but what we're trying to figure out is what the statute actually means, or what the Constitution actually means. But we still always think like lawyers, and thinking about lawyers, we always are asking, well, what's the proper legal argument that we need to worry about to the extent that we consider the Constitution to be a legal document? We could, and I swear I'll stop in just a moment, we could view the Constitution as being a political document that is full of political principles. And we can say that the principle supporting the 14th Amendment says yeah, generally speaking, we shouldn't allow people to run and win after taking an oath and violating the oath. But any political principle could be overridden by the times. So if you happen to be someone who says, I think the Constitution is a political document as opposed to a purely legal document, then a different set of arguments comes up in terms of the final question of whether you disqualify a particular individual from running or not. So it's a messy thing. And those are things, if you happen to listen to the argument tomorrow, or I'm sure they'll post it, when you listen to it, listen for the arguments that sound legal versus the arguments that sound political. And distinguishing those things, and when you are clear that you distinguish those things, that's when you know that you are becoming an even stronger lawyer.
Oh, we got so many people now.
In this situation, why would we want to be lenient? I mean, I'd rather have a 34-year-old immigrant as a president than somebody who clearly doesn't respect the entire system.
You want to take that one first?
Sure. Right, I'm with you. I'm with you there. Of course, we would all concede that the country is divided as to the appropriateness of Donald Trump as a candidate for office. And the structure of Section 3, I think it's very odd to me. This is such an it's a prior restraint on the right to decide whether or not Trump is a bad guy. They have a prior restraint on the right to vote. Notice that it doesn't keep that, however you want to characterize the, why would I want to be lenient with this bad person? I mean, you describe the thing. Notice that Section 3 doesn't keep the bad person out. It doesn't keep Robert E. Lee out. It doesn't keep Jefferson Davis or pick your bad guy, right? It says, wait, we don't know if we want to let you vote for that person. Okay, you guys, do you like this person? Do you like this person? Yeah, do we like it? Okay, we like it. Okay, go ahead. That's an odd thing, right? To me, it only makes sense if you have reason to worry about who they're picking in the southern states. Right? Maybe you would want Congress, a national body, to say, hold on, our bad guys still, in control down there because those states have just done a lot of really bad things. But the idea of telling the American people, you're divided as to whether or not this is a bad guy, but we know bad guys better than anyone. And we certainly know nefarious politicians better than the American people do. So you have to wait. You have to wait and let us discuss that. And that, to me, that just does not make sense. We're divided over whether or not it's a nefarious person. Let's take it to the
So that should raise an interesting question. I mean, I've seen in 2024, we at least don't need to look at Robert E. Lee's statue on Monument Avenue. I mean, I have to admit that we were pretty divided as a country, not me personally. We were divided as a country as to whether Robert Lee was a good guy or a bad guy. So part of the question is because Lee, of course, had taken an oath to support the Constitution when he became a military officer in the U.S. Army, before he then left, resigned it, and went over to the Army, the Confederate Army. Jefferson Davis had taken an oath as either a Mississippi rep or I think Mississippi senator, U.S. senator from Mississippi. So yeah, so he had taken the oath. So he had taken an oath and violated the oath, because I think we can all agree that the Civil War qualifies as an insurrectional rebellion. Granted, some people called it the late unpleasantness, but still, I think it's fair to say that.
War of Northern Aggression.
Whole shebang, right? Yeah. So those folks were barred from serving in every other position that's covered except the presidency if we take the position that the office of presidency isn't covered. That is, Robert Lee couldn't serve as U.S. Senator from Virginia. He couldn't serve as a judge in the state of Virginia or the Commonwealth. Jefferson Davis couldn't serve as senator from Mississippi, couldn't serve as governor of Mississippi, couldn't serve in any public position except President of the United States. We got a long way to go to get over that one as to why that would be the way that we would read the provision. Now, maybe we should, but that's a long way to go. I will say that in terms of talking about the people voting, we remember that the people don't vote directly for president. And I'm not just talking about that it's not a national popular vote. What I mean is we vote for the electors for president. Indeed, one need only go back to Bush versus Gore in 2000, the Supreme Court case where they hopefully reminded us that the only reason why we have what even looks like a vote for president is because state legislatures allow us to have a vote for president. So practically, it's true that we are voting kind of for president if we also live in a state that says no faithless electors. But technically, from a constitutional perspective, we don't vote for the president directly. So in some ways, it's not taking our vote away. And we got to be careful about how we say this. In this context, it's not taking our vote away from a democratic perspective to say you can't vote for this person for president because technically we can. So it's messy when we go back to the thinking of the 1800s and the late 1700s and thinking about this particular issue. And here, in fact, I'll add one more piece, and that is this: how things change over time. In the late 1700s, when we got the original electoral college, and even in the early 1800s, states would choose electors and didn't require the people vote for them. Many did, but some did not. By the time you got to the 1860s, everybody was essentially voting for president, and the assumption was the electors would vote for the person who won the popular vote in the election. So it's interesting that as times changed through America, our vision of what voting was changed, and as a consequence, the vision of voting when the 14th Amendment was passed is actually different than the vision that existed when the 12th Amendment was passed, for those Hamilton fans, or in 1788, 1789, when the Constitution was ratified.
I kind of wanted to draw the attention to this second half of Section 3, the shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof. I think there's a lot of ambiguity in that as well that we haven't necessarily addressed. We just talked about bad versus good guys, but what do you all think the court will be saying in regards to that? Because I think that is another issue that is definitely at play here.
Great question. And it's one, if I had enough time, that would be directly where I would direct my research. Because you can kind of tell just from my opening statement that I look at these phrases not as individual words, but look at them as legal phrases of art. And even though a lot of questions have to do with, in the public debate, was there an insurrection, right, during January 6th? And there are questions about that. But that isn't what I would look for. I would want to know how they understood the entire phrase. What is an insurrection or rebellion against? And then now we have to do some tricky work, right? In my mind, I think it is trying to say insurrection or rebellion against the Constitution of the United States, but I've heard people take different positions. So already we're at a kind of ambiguity. And then the question would be whether or not they were using it as a term of art to refer to the Civil War, right? Or things like the Civil War. We have people, Ohio speeches, John Hanna talking about this is to cover the Civil War or any similar crime in the future. What is it? Is he something similar to the Civil War? And the court tomorrow, I think, is going to address exactly the question that you're raising. And you're going to hear questions about should we treat a 3 or 4 hour riot the same way that we treat a 4-year war that led to 600,000 deaths and just massive economic destruction and a 1 million-man army that the Confederacy put into the field. And I think that's a major issue that is going to trouble some of the justices. There are people writing on it, and but it's going to be part of that oral argument.
Yeah. It's a big messy question. There are a couple different ways of thinking about it. One is whether an insurrection should be thought of in terms of scope and scale. That is, if the court's position is insurrection or rebellion means something similar to the Civil War, then we're probably done here. Problem is, I've seen folks who have made a pretty convincing argument that insurrections don't have to be large. Rebellions don't have to be large. Folks didn't have any problem talking about slave rebellions, and we certainly didn't have any slave rebellions that were the size of the Civil War. And we certainly had slave rebellions or slave insurrections that were quite contained and frankly caused less damage than what happened on January the 6th. So if one takes the vision of insurrection relatively, I won't even say narrow, but takes insurrection in the way they thought of it arguably in the 1800s, and frankly even the way we think about it now, because there's some courts that have decided, including Colorado, have decided that what occurred was an insurrection, then wow, we're there. We add one more piece of the puzzle, and that's this. At some point, we're going to have to look at ourselves and ask what we think happened or what we think was supposed to happen on January the 6th. And I've said this to a couple folks in the last couple weeks, and I hope folks consider it, and that's this. Even I have taken the position that January 6th was not, in my mind, was not what I was seeing in front of my face. In part because what I was seeing in front of my face was arguably too horrific to imagine. That is, if you believe that the crowd was going to pull Mike Pence out of the Capitol and hang him, that has to be an insurrection. Now, if you think it was play acting, that's different. But if you actually believe that the number 2 person in the government was going to be marched out and killed, or if they were going to do that to the Speaker of the House, Nancy Pelosi, at that time, then you have to believe that that's the kind of thing, and that's the kind of insurrection and action that would trigger the 14th Amendment, Section 3, because if that doesn't, then nothing will. And that's going to be something to listen to as well, as how do folks view what happened on January 6th? Tourists visiting the Capitol, as some folks have suggested, or an insurrection where folks thought about possibly killing members of Congress in order to get their way. That's something we're going to have to face. That doesn't sound like a legal question, but it is relevant to the legal issue, as you noted. And that's a tough thing. And it's something we're going to have to reckon with as a country.
Well, I guess quickly, that's right, and it does have to do with, part of the issue has to do with what do you think was happening, and what were the motivations and the intentions behind different people in the crowd. I think I kind of resist some of your definition of insurrection. We already have real-life examples of people trying to kill members of Congress and setting themselves up as a sniper and shooting at Republican representatives, Steve Scalise, right? And no one called that an insurrection or a rebellion. It was a murderous attempt on the life of representatives. There are people who went to the houses of Supreme Court justices with the intention of taking them out. That's a crime, and that person is being prosecuted for it, but no one characterizes that as insurrection or rebellion. And in terms of the pictures of the riots, I don't know where you grew up, but I imagine both of us, a little older, okay, I'm a lot older, we're somewhere older. I remember the riots of Albuquerque during the 60s and 70s. I remember the deaths and destruction that happened during the riots, the Vietnam riots. And I don't remember anyone talking about those as insurrection or rebellion. They were murderous, criminal actions that were trying to hurt people and disrupt state operations. So we have a long history of really violent, ugly stuff that is often directed at politicians and other people. And I'm not sure that even if, whatever the violence and mayhem of January 6th involved, I think there's a real question as to whether or not it was a terrible thing, or whether it was both a terrible thing and an insurrection or rebellion against the Constitution of the United States. It may have simply been a terrible thing.
So that actually raises an interesting piece of the puzzle, and something we've got to be careful about. Because we always have to ask the question, to what end? I am not a fan of violence against anyone. But there's a difference between violence for violence sake and violence for the purpose of overturning an election. It's the overturning of the election that triggers the issue of insurrection, and whether it's an insurrection or rebellion against the Constitution or against the United States. So there's no question, unfortunately, we've had a number of people who have been harmed, killed in public service. It's not the harm in public service, it's we're doing this in order to overturn an election that triggers the insurrection and triggers those kinds of issues. So that's when you got to be careful about, which is not to say that other folks, particularly folks who may well be trying to go after Supreme Court justices in particular. Right? One, because they're lawyers, so we're really not happy about that. But the idea that if they're trying to do that in order to change an outcome, that moves, I think, us a lot closer to the question of insurrection. If they're just doing it because they're mad at what someone has done in the past, that's different. Or they don't like their politics, that's different. Horrible, but that's different. But when you're doing it in order to affect government actions, that's where you move into questions of insurrection. So that's sort of a piece of the
I agree.
Well, we could stay here forever, but we're not going to. However, I know that we all have places to be. Classes have to take place, and thank you both